Good evening, ladies and gentlemen. Thank you for coming out this evening for our Constitution Literacy Series. This is our second event for this academic year. If you haven't had a chance to watch or to go back and watch our first Constitution Literacy Series from last month, we encourage you to do so. We will begin our event with an invocation which will be offered by Aubrey Mason, after which Carter Howson will lead us in the Pledge of Allegiance.
Our dear Heavenly Father, we are so blessed to be here. We're so grateful for Mr. Hancock and Mr. Hymas and Mr. Brewer and their work in preparing this. We ask Thee to bless them and help them articulate their points that they make. We ask Thee to help us be filled with the love of God and to serve those around us and to be civil and kind, even when we disagree. We love Thee and ask for Thy Spirit to be with us here tonight, and we say these things in the name of Jesus Christ. Amen.
Please stand and join me in the Pledge of Allegiance. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Thank you, Aubrey and Carter. Now it's my pleasure to introduce our debaters this evening. David Hancock is a member of the AHS High School faculty. Prior to joining American Heritage in 2010, David was a practicing attorney. He is a cum laude graduate of BYU Law School and has argued dozens of constitutional issues in court. Mr. Jeff Hymas joined the American Heritage School in 2016 after working with many organizations, presenting hundreds of Constitution education lectures to live audiences across the United States. He holds an MBA from Idaho State University and is a magna cum laude graduate of BYU Marriott School of Management. My name is Adam Brewer, and I joined the American Heritage faculty last year, and I will be serving as the moderator this evening. Tonight, we are excited to be discussing the topic of the Supreme Court. We will first hear a brief lecture from Mr. Hancock, who will teach us about the basics of the Supreme Court and how it functions in our political system. After which, we will take a short break. Then we'll have a moderated debate between David and Jeff. After the debate, audience members will have the opportunity to ask questions in a Q&A session. We encourage you throughout the debate to think of tough questions, to ask our subject matter experts here in this session. And let's begin by giving Mr. Hancock a round of applause.
Thank you. I was thinking about that and thinking asking an attorney to give a brief lecture is like asking an old man to take a short nap. Unfortunately, I'm kind of in both camps, so it's a little bit difficult. Do we have the PowerPoint? We can watch this video. It's a great one. It hasn't been recorded yet, so I'm not sure what we're doing. All right. I'm excited to talk about this today. The Supreme Court is something that I am very excited about and something that I know way too much about. And so if I start putting you to sleep, just nod off and I'll wake you up when the time is right to cheer and to scream loudly. All right, let's just do a quick little review here about the United States Supreme Court. First off, we have in the Constitution three branches of government. Congress, Article 1, it's the longest article of the United States Constitution. You can see that up there in the top left. Article 2, the executive, is the second longest article of the United States Constitution. And then we have, down here in the bottom middle, is the United States Supreme Court, which it's not quite the shortest article of the United States Constitution, but it is pretty short. But just know that these are the three branches that the Constitution talks about. And I want to just give a couple of quick facts about the Supreme Court. This is actually an old picture. I couldn't find the one that they took 2 weeks ago, which, with a new justice of the Supreme Court. So this one has Justice Breyer here sitting next to Chief Justice Roberts. So we do have a new Supreme Court this year, but just so that we know who we're talking about, this is the group. The Constitution really doesn't say that much about the Supreme Court or what the court is supposed to do. There are only in Article 3 sections. One of them has to do with treason and trials by jury, and the other two have to do with the Supreme Court, but there's really not that much detail. So I've edited this a little bit, but this is the first section of the Supreme Court that has what I would say is the bulk of the information, and it says there, the judicial power of the United States shall be vested in one Supreme Court and in such inferior courts from time to time. Congress may from time to time ordain and establish the judges both of the Supreme and inferior courts shall hold their offices during good behavior and shall at stated times receive for their services a compensation which shall not be diminished during their continuance in office. And that's really the most important part. There is one other additional section that has some important things in it. And it says, the judicial power shall extend to all cases in law and equity arising under the Constitution, the laws of the United States, and treaties made or which shall be made under their authority. In all other cases before mentioned, the Supreme Court shall have appellate jurisdiction both as to law and as to fact, with such exceptions and under such regulations as Congress shall make. And this really tells us the bulk of the information that the Constitution has about the Supreme Court. So let's take a look at some of the things that it says. Okay? First, all judicial power is held by the United States Supreme Court. It doesn't really define what judicial power is. It just says that that power is vested in the Supreme Court. Judges hold their office for life. When appointed and confirmed by the United States Senate, they can hold that position for as long as they live, unless they are removed by Congress, which we have that they can be removed through impeachment. Their pay can never be reduced during their service. So if they start off at a certain salary, they have to continue at least that much for the rest of their life. It's not a bad job. Jurisdiction of the court extends to all cases under the Constitution, the laws of the United States, and the treaties of the United States. Now, there's a few other things that are mentioned in there, disputes between ambassadors and some other things, but they're really not that common. And the court's original and appellate jurisdiction is specified by the Constitution. We'll talk about that in a little more detail a little bit later. And last, Congress can create what is called inferior courts. Now, exactly what that means is open to a little bit of interpretation. Now, there are some other provisions about the Supreme Court in these other sections. The three most important. Two of them are in Article 2, and one is in Article 1. In Article 2, it provides that the President appoints and the Senate confirms justices of the Supreme Court, which means that in order to sit on not only the Supreme Court, but all of the what we call Article 3 courts, you have to get the approval, the advice and consent of the Senate. So the two legislative bodies are acting. Second, judges can be removed by impeachment. That's in Article 2, Section 4. And the Chief Justice of the Supreme Court presides over any impeachment trial of the President of the United States, which is actually kind of interesting. I remember during the impeachment trial for Bill Clinton, Chief Justice Rehnquist had designed a special judicial robe to wear to the impeachment, and it had gold stripes on it. It was really pretty fashionable. Almost as fashionable as Mr. Hymas, by the way. I'm trying to get whatever licks I can into him because they ganged up on me last time. So I'm now about everything else about the Supreme Court. The Constitution's silent, and this is something that actually shocks or dismays quite a few people. So these are some of the things that the Supreme Court says nothing about. How many justices sit on the Supreme Court? Really unusual. The Constitution says how many representatives in the House, how many senators, how many presidents, etc., but nothing about the number of justices of the Supreme Court. It has no qualifications for being a member of the Supreme Court. Under the Constitution, you don't have to be a citizen of the United States. You don't have to be a particular age. You don't have to have lived here for a long time. It's completely silent on that. There's no information about how a case gets to the United States Supreme Court, and the Supreme Court, it's completely silent, or at least mostly silent, on the role that the Supreme Court plays in interpreting the Constitution. That's going to hopefully be part of what a big part of what we're debating today. Now, the way the court is set up today, there are 9 members of the court. It's been that way for more than 150 years. There has been as few as 6 and as many as 10 at various points of our history, but in 1869, Congress established the number of justices on the Supreme Court at 9, and it's been that way ever since. There are 3 levels of courts. We'll talk about more about this in a little bit. Justices currently of the Supreme Court do not serve on lower courts. Now, this is different from the way they did in history. Historically, they oftentimes served as district courts, and they also rode circuit and went around and heard appeals. Every Monday, or the first Monday in October, the Supreme Court's term starts every year. And it's also the title of a book and maybe a movie too, if I recall correctly. And their term usually ends in June. They can go as long as into July. They have to wait until all of the decisions are published, but it usually ends in June. And the court sets all of its own rules. They're not set by Congress. They're not signed by the president. And the court also decides what cases it's going to take. It has the ability to decide to grant a case or to completely ignore a case. Nobody tells the court what cases or issues they're supposed to look at. All right. One of the myths that there is in the United States Supreme Court is that the Supreme Court is very, very divided. And that's partly because the only cases we ever talk about in the news are the 5-4 decisions. But the 5-4 decisions are a distinct minority of the cases that are decided. In fact, nearly half of all decisions decided by the Supreme Court are either 9-0 or 8-1. And that is really quite remarkable. And if you add in the 7-2 decisions, you're up around 70% of the cases. And so the vast majority of cases decided by the United States are, as far as the public are concerned, relatively unremarkable. And so this is something that a lot of people don't understand. I remember one time I was talking to Jeff in the faculty lunchroom about this, and I mentioned that to him, and I don't know how surprised he was about it, but I thought it was an interesting fact at the time, and I thought that you folks would enjoy learning that as well. Okay, the 3 courts. Congress has established 3 different levels of courts in the United States. The lowest level, the district court, is where cases begin. In the district court, the judges are responsible for making decisions of law. The juries or the judges are also responsible for deciding issues of fact. They get to decide what the facts are. After that, it's all appellate jurisdiction. So in the circuit court, the court is only deciding issues of law. All they get to decide is, did the district court make a mistake? And the same is true in the United States Supreme Court. However, the United States Supreme Court has made it a policy or a practice to only decide cases when it's either an important constitutional issue, a unique question of statutory law, or when there is a division between the circuit courts in the United States. And that's because our circuit courts are divided up between 13 geographical districts in the United States. Now, Marbury versus Madison is perhaps the most important case that the early United States Supreme Court decided. And in Marbury versus Madison, the court essentially granted itself a power that is not expressly discussed in the Constitution, called judicial review. And Marbury versus Madison is a case that whole books have been written about. It is a fascinating case. It's got some wonderful characters in it, including the Chief Justice of the United States, who had just left his job as the Secretary of State for the United States, John Marshall, my favorite Justice of the Supreme Court, and James Madison, who was the incoming Secretary of State, later to be a President of the United States, as well as a whole bunch of perhaps shenanigans that were going on behind the scenes in order to make this, I think, one of the most interesting cases that did relatively little. And it all revolved around the switch of parties from the Federalist Party to the Democratic-Republican Party in 1800 when Thomas Jefferson was elected. And there were some things going on about appointments of judges, and one of those judges who was appointed by President John Adams, and who didn't get his letter telling him that he was now a judge, he sued. And he decided to bring a case in the Supreme Court originally. Now, if you think back to that original part we looked at, you might be thinking, wait a minute, I'm not sure the Supreme Court can hear that kind of a case. And that is ultimately where the case turns on. It's a very long case with a very convoluted argument and logical section, but one of the most important questions that the court decides to address is this essential question. Does the Supreme Court have the power to give this order that the person is asking for, Mr. Marbury? And what the Supreme Court ultimately decides is no, they do not, even though Congress gave them that power. And they ultimately rule that the United States Constitution prohibited Congress from doing this action. And it's a wonderful case, and it's exciting and interesting. I encourage you all to go and read it. For someone like me, it's what I call a real page-turner. But for you guys, maybe not so much. But it really is a foundational case in our democracy. And I'm going to just point to a couple of things. I'm not going to read all these slides. I'm going to look at them. This is the law that authorized the Supreme Court to take the action that Marbury asked for. This here is, of course, Article 3, Section 2 of the United States Constitution, establishing the original jurisdiction of the court. And then we have a couple of really wonderful quotes here from the opinion where Chief Justice Marshall is explaining the decision of the court. And where he talks about the conflict between a written constitution and a law. And some people were arguing that the United States Constitution could just be ignored. Congress could go ahead and enact any old thing that it wanted to, that it was as much of an interpreter of the Constitution as the Supreme Court was. And you can see up here that what Chief Justice Marshall said is no, this is a limited set of powers given to government, and if government can just ignore those limitations, then it really doesn't mean much. I love this particular quote. Certainly all those who have framed written constitutions contemplate them as forming the fundamental and paramount law of the nation, and consequently the theory of every such government must be that an act of the legislator repugnant to the Constitution is void. I think that is a wonderful, wonderful sentence. And to a lawyer like me, it really says a lot. When something is void, it means it had no effect. None. It never could have had any effect. This particular part here is perhaps the crux of the decision for our purposes today. And the important part is down here after the ellipses, about 5 lines down, where it says, "It is emphatically the province of the court, and duty of the judicial department to say what the law is." What Chief Justice Marshall argues is that inherent in the judicial power is that a judge must interpret the law. Inevitably, in any two conflicting laws, you will have some space in between them, what we might call gray areas. And it is the power of the judiciary to decide what it actually says. Another justice of the Supreme Court famously said, "We are not final because we are infallible. We are infallible because we are final." And what he meant by that is the United States Supreme Court has the last word on the case, on the issue. And as a result of that, the United States Supreme Court is the one that gets to decide what the law is, what the law says. And by extension of that, it's the one that decides what the Constitution of the United States says. Thank you very much.
Excellent. Thank you, Mr. Hancock. We will now break for 5 minutes. There are refreshments in the lobby. We ask that you keep them in the lobby instead of bringing them here into the North Auditorium. We will come back in 5 minutes for our moderated debate. So we'll see you back here in 5. Thanks, everyone. Okay, let's, for those in the audience, why don't we do a round of applause just to get those that are in the lobby to come back in. So, round of applause. Yay. Okay, we're going to get started. Yeah, Aubrey, if you wouldn't mind, thank you. Yeah. Okay, welcome back. We're going to get started with the moderated debate portion of our meeting. We appreciate Mr. Hancock and his lecture for us and getting us up to speed in terms of the basics of the Supreme Court. As I listened to David's lecture, what was most compelling to me is just the fact that the Article 3 doesn't really say very much about or give us a lot of context in terms of what the founders thought the Supreme Court should actually look like, or what the role of the Supreme Court should be. Specifically, Mr. Hancock talked about judicial power and how that's not defined in Article 3. So my first question for our debaters this evening, I'll throw this one to Jeff first, is what to you is judicial power, and what is overall the role of the Supreme Court, in your opinion?
Yeah, that's a good question. So I think maybe you listen to what David told us about, and it makes sense. Obviously, you have to have a judicial side. They're judging whether something is right or not. Otherwise, Congress and President can do whatever they want to do. You have to have a judge who says, hold on a second. The interesting point that David did make, and Adam's already emphasized, is that the Constitution itself doesn't say what that really is. And what I think my main difference of opinion on that is that when in Marbury versus Madison, they gave themselves the power of judicial review. That's something that that wasn't there until they created it in this case that they listened to, right? And this idea, when it said that it is the province and duty of the judicial branch to say what the law is, that's where I fundamentally disagree. I don't think that is the job, because Article 1, Section 1, Clause 1 says all legislative powers herein granted shall be vested in a Congress of the United States. And to me, all means all, right? So all the legislative, all of declaring what the law is and stating what the law is, writing the law, deleting the law, voiding the law, all that stuff is clearly within the purview of the legislative branch, not within the purview of the judicial branch. So when they give themselves the power in Marbury versus Madison to say what the law is, to me, fundamentally, that's the challenge. I don't have a problem with them coming and saying, hey, in our opinion, this is not constitutional. In our opinion, this shouldn't apply this way. In our opinion, Congress shouldn't have written this because it violates, Articles 1, Section, in whatever parts of the Constitution. I don't have a problem with them saying that. But in my view, their job is to issue that judgment and state that, and let the Congress, whose job is to make or void the law, act from that point forward. What we got to a point is that the legislature doesn't make laws. Essentially, as we are today, our judicial branch, the Supreme Court is the one making all the laws, because they're essentially saying, you follow what we say, we interpret, and we say what the law is, and therefore, in my view, that they've taken the power to write law, the power to create law, from the legislative branch and set it firmly in the judicial branch. I think that's our problem, is the judicial branch is way too powerful. And if you just, I could go on and on, right? But I'll stop after this. And the challenge is you have essentially 5 black-robed justices who decide everything about America. Instead of this representative republic that we live in, it should be the 435 reps and the 100 senators. They're the ones who should decide, because they're the ones that we're electing. They're the ones that have to answer to us. We kick them out if we don't like them, right? When we have the voting every 2 years, every 6 years. That way it puts the people ultimately in charge of what's going on, instead of just some untouchable justices who have appointed themselves way back when to be the distinguishers of what the law is. So that's kind of my rant.
So just to clarify, Jeff, thank you so much for your thoughts on this matter. So just to clarify, you're essentially stating that your problem isn't so much with the fact that the court says this is what the law should be, but that those decisions are binding, or that because of judicial review and because of Marbury v. Madison, they actually have the ability to strike down law that has been passed by our representatives in Congress.
Yeah. In my mind, Article 3, Section 2, David read it, it says the jurisdiction of the Supreme Court shall extend to all cases, and it says to all cases, to cases, to cases. It describes what those cases are. Then it has, I think, 3 times it says to controversies, to controversies, to controversies. It's very, very clear that the jurisdiction of the Supreme Court is just to the case. And therefore, the decision they make is totally binding, and it is the last. It is infallible because it's the last. You don't keep appealing past the Supreme Court. It is the last decision in the judicial area, and that it's binding on the litigants, the people who are suing in the case, that's depending on the circumstances of the case. But to say what they decide in that case is now binding on America, for example, Roe v. Wade in 1973, we decide that abortion now is legal, and even though 80% of America at that point is against abortion, we all just say, shoot, I guess we have to do that. There are provisions in the Constitution. Article 3, Section 2, Clause 2 says, and we read that as well, that the jurisdiction is restricted, can be restricted by Congress. Under such regulations and exceptions as Congress shall make is the wording it has. And so Congress can actually limit that and say, no, you're not going to go beyond this. Why? Because in my view, I think maybe that's one of our fundamental differences too, is I feel like Congress is not only more powerful, but intentionally more powerful. It's more powerful because it represents most directly the people, and the people are the ones in charge. And even though the Supreme Court gets to issue their opinions, and that's all they are is opinions, in the end, the people get to choose, and they choose through their elected representatives. They're the ones who make the law and define it and void it. Yeah, so in short, yes, I think that the jurisdiction is to the case, and we give it way too much credence. There was a case, Roe v. Wade, where they said a lady could have an abortion in Texas, and next thing you know, everyone in America can have abortions because 6-3, 7-2?
It was a 7-2 decision.
7-2, because 7 justices thought so. Like, hold on a second. So anyway.
Thank you, Jeff. David, how would you respond?
On this one, I just respectfully completely disagree with Jeff. I think he's completely wrong.
That's how you really feel, David.
If Congress is allowed to decide what the law is, Congress can just say, well, the Constitution really means this, and we're going to pass a law that says that. And it basically means that the Constitution is no real barrier, no real check on the power of the legislative branch. And the legislative branch has the ability, better than any other branch, to be tyrannical. And as a result of that, the Founding Fathers well knew that that was the real risk with Congress, is that Congress had the ability to grant itself power after power after power, and to completely ignore the restrictions and walls that were erected by the United States Constitution. And as a result of that, they had this system of checks and balances. And the only way that the judiciary can check Congress is to decide what the Constitution says. Now, that doesn't mean that Congress has no remedy. Congress is the one that gets to get the ball in action as far as amending the Constitution of the United States. And so if Congress believes that the judiciary is wrong, that the Supreme Court got an issue wrong, they simply approve an amendment to the United States Constitution and send it out to the people and see if the people agree with it. And we've seen that happen a number of times. And as a result of that, the legislature is not completely powerless in the opposition of a court. Keep in mind, too, that Congress is the one that gets to remove members of the Supreme Court if they wish through impeachment. So Congress is not completely powerless in the face of this overwhelming mighty court. In fact, the court has relatively very little power. The only thing they can do is interpret cases, and those interpretations are then binding only on courts. That's a fancy Latin doctrine called stare decisis, but it basically means that we stand by the decision. We stand by the prior thing that has been decided, called precedent. And so that's the way that the Supreme Court checks the power of the legislature, is by deciding what it is that the law says. If Congress disagrees, Congress can change the law, or they can institute an amendment to the United States Constitution.
Thank you, David. So just to clarify your position, I mean, essentially you're suggesting that without the power of judicial review and without the ability of the court to say what the law is, then the possibility of Congress becoming tyrannical or being able to basically determine what is constitutional or not constitutional is actually a threat, right? That this check that the court has given itself is actually an important check in our constitutional system that basically prevents Congress from having unfettered ability to both interpret the Constitution and legislate at the same time.
Yeah, I think that's absolutely right. And you see an instance of that arising fairly early in our republic with the Alien and Sedition Act, which was enacted by Congress in the first, was it the first year or the first couple of years of President John Adams?
During the Adams administration.
During John Adams' administration. And in the Alien and Sedition Act, they completely ignored the First Amendment guarantee of freedom of speech. And Congress created a law prohibiting free speech. Basically, it was illegal, punishable by fine and or imprisonment to criticize the government, which was something that was really quite remarkable. These were the founding fathers who decided this. And so the fear of the founders that the legislature would become tyrannical, I think is a real and a genuine fear. And it is predominantly the United States Supreme Court which has stood between that tyranny and the people of the United States.
Can I jump in? So a thought a thought occurred to me. So the issue is not, everyone's in agreement that certain branches of government can become tyrannical. I don't think that's why we have checks and balances. We know that there's, men aren't angels in government, like Madison talked about. They have to have checks on each other. The question I have, and that I'd pose, is, okay, so the issue is, who's going to interpret the Constitution? Should it be Congress, who's checked by 535 men and women who are accountable to the people? Are they going to be the ones who I would rather have power in their hands and trust them because they're accountable to the people than, say, 5 Supreme Court justices, or 9, however many you want to say, but you really only need 5 to do whatever you want to do. That's what I think is at the root of this issue, is to say, well, gosh, we got to watch out for Congress, because Congress may get tyrannical. They may do all kinds of crazy stuff. They may take all this power into themselves, and the judiciary is there to check them. I agree the judiciary is there to check them. But if you switch it the other way, and you say, no, the judges get to decide, well, then all you're saying is it's a different group of people who get to decide what the Constitution says. And those different group of people are unelected, they're appointed for life, and they're untouchable to the people. And it's become very, very political these days. I'd way rather have the power vested in Congress, 535, and spread and balanced and had to be renewed every 2 years, every 6 years. I'd way rather have that dangerous power in the hands of the people through their elected representatives than in the hands of the judiciary. There's an interesting quote by Thomas Jefferson. He said, "The germ of dissolution of our federal government is in the composition of the federal judiciary, working like gravity by night and day, gaining a little today and a little tomorrow, and advancing its noiseless step like a thief with a field of jurisdiction until all shall be usurped. To consider the judges as the ultimate arbiters of all constitutional questions is a very dangerous doctrine indeed, and one which would place us under the despotism of an oligarchy." He says, super dangerous to say they're the ones who are in charge, because if they're in charge, an oligarchy is ruled by a few, right? The few is 5. The rule is just a few people. If you say they're the ones who actually decide what the Constitution says, I think that's more dangerous than saying letting the Congress decide that. And I'll just give you one other example. In the Dred Scott decision with Abraham Lincoln, he came out and said, if the policy of the government upon vital questions, well, so first of all, the Dred Scott decision is a decision in 1858, I think, where the Supreme Court came out and basically said that Dred Scott couldn't sue because he wasn't a citizen, and black people never had been citizens and aren't citizens. It's a really bad decision. But it stood, right, because it was the decision of the Supreme Court. And Abraham Lincoln says, look, if the policy of the government upon vital questions affecting the whole people is to be irrevocably fixed by decisions of the Supreme Court, the people have ceased to be their own rulers. They may say some things, and he said in here, we should have high respect for what their opinions are, but they are just opinions, and the people who get to decide are the people. And it shouldn't be that the Supreme Court makes that decision. Otherwise, the people are no longer governing themselves. They're being governed by the Supreme Court. So I don't know if that added any flavor to the conversation. But
Sure did. David, do you have any rebuttal?
he's dead wrong.
We live in a republic, and the people actually don't rule. The people elect representatives. The representatives then take actions. They pass laws, and they approve justices of the United States Supreme Court. And so in the approval of those justices of the United States Supreme Court, the people are acting. And keep in mind, the people can remove justices for high crimes and misdemeanors, and we know that high crimes and misdemeanors are whatever Congress says they are. And if there is a sufficient willpower on the part of the people to remove a Supreme Court justice or to change what the Constitution says, then it can be done. And so I don't really see that the justices of the United States Supreme Court are in any way tyrannical against the majority of the people. And where the United States Supreme Court really excels is protecting the rights of the minority. So just to go back to our last month discussion, if Congress was next week to decide to eliminate gun rights in the United States, which is something that they have talked about and something that is possible under the current Congress, who's to tell them that they can't do it? The president isn't going to do that. Who will? Supreme Court of the United States is the one that would do that, because they're the ones that will step in and will say, no, that's not what the Constitution allows. In order to do this, you need to get an amendment to the United States Constitution. Congress, you can't do that. So this is what James Madison called the tyranny of the majority. When a majority of the people of the United States want something that is contrary to the United States Constitution, the Constitution stands between the majority and the rights and privileges of the minority. And the Supreme Court and the courts in general are the ones that uphold those rights. Everybody else is beholden to the majority. The courts are independent, and as independent actors, they are able to take actions to protect those minority rights.
Go ahead. Can I jump in? So sorry. So in the hypothetical where the Congress takes away your gun rights, I would say, well, what about the practical? Like, what about the real? What actually happened? Right? In 1973, gave the right to kill unborn babies. Like, that happened, and the Supreme Court did that. And so
they also undid that.
They also undid that, but it took them, oh boy, what, 45, 50 years? Where's my math? It's almost exactly 50 years, I guess. Yeah, really close. And I would suggest, here's the solution. In Article 3, Section 2, Clause 2, it says, in all of the cases before mentioned, the Supreme Court shall have appellate jurisdiction both as to law and fact. Here's the part that matters. With such exceptions and under such regulations as the Congress shall make. So the jurisdiction of the Supreme Court can be accepted and regulated by who? By Congress. And so what Congress should have done, in my opinion, in 1973 is they should have said, oh, that's interesting you ruled that way in the case of Roe v. Wade. That was an individual case. They can't, the lady, I guess, does now have the right to seek an abortion. But that decision is limited to simply the case. Now, an informed Congress and informed people who are not apathetic and ignorant, who understand the Constitution, Article 3, Section 2, Clause 2, will say, Congress, we demand that you now limit and make exceptions to what they'll rule on. And we're no longer going to let you rule on abortion as a federal issue. I believe that's not only a good idea, but I believe it's a constitutional idea. It's right there enshrined in the Constitution, Article 3, Section 2, Clause 2. I love that they overturned it this year. But they should have overturned it in 1973, 50 years ago, and saved millions and millions of babies, understanding that the judiciary isn't the branch who says what the law is, and it applies to the rest of eternity. Congress is the one who gets to decide that, and it says right there, with such exceptions and under such regulations as Congress shall make. Congress and Ron Paul, for 3 or 4 years in a row, introduced a Sanctity of Life bill, and he said, let's use our Article 3, Section 2, Clause 2 power, and he wrote a bill and said, and it didn't get passed, okay, it was just, oh, that's a crazy idea. It's not a crazy idea, it's a great idea. We're going to limit and not allow the federal judiciary to rule on abortion. They got it wrong. Who's in charge here, them or us? Just like you say, well, what if Congress takes our guns? Okay, I think it's really good. I think it does. There's very much a great legitimacy in the idea that judiciary can protect the rights of the minority. But what I think we need to understand is that the Congress has the ability to step in, acting for the people, and to save us from the tyranny of the few, the tyranny of the 5 justices, the tyranny in this case of 7 justices, who turned America in a lot of ways unchristian, right? Full-out abortion. There's a remedy in that. It doesn't have to wait for the Supreme Court 49 years later to say, hey, we probably should overturn that. We've now got the conditions and the right amount of justices who think conservatively. Why do we have to wait 50 years for the right situation to show up? Why can't we just change it by using the Constitution as it is, the remedies that are in it in Article 3, Section 2, Clause 2?
I'm just going to jump in here at the end. Adam's going to have an easy night tonight.
This is great. This is great entertainment right here.
I think that Jeff's example shows the possibility and the risk for legislative tyranny. If the legislature can just exempt itself from Supreme Court review anytime it wants to, that's a real huge problem. Because it says, hey, we're going to enact a law, and we're going to make sure that the Supreme Court can't rule on this law. And so I think that Ron Paul's idea about creating an exception to the appellate question was unconstitutional itself, first off. And secondly, it wouldn't have actually solved anything, because the decision of Roe v. Wade would have stood, And it would have still been binding on the circuit courts. And the circuit courts cannot have their jurisdiction, their appellate jurisdiction, limited by Congress. Federal courts still have to decide this question. And at the end of the day, if you don't have uniformity in the United States government with regard to what the Constitution says, then we are no longer a union. And that has the risk and the possibility of leading to dissolution of the union. And so there needs to be, in federal law, and especially with regard to what the United States Constitution says, there needs to be a consensus, an agreement as to what it says. But the way that we do that is through the United States Supreme Court. And the alternative is essentially chaos.
You're right. I don't mind. I don't mind if the Supreme Court rules. They can rule, and I think it's great. And what happens, just logically, what happens when a law is passed by Congress and the Supreme Court says, hey, that's not constitutional, we rule that way in this case, they send a signal to Congress, and Congress has some options. Congress can say, you know what, you're right. We need to rewrite the law, because it's our job to write the law, not your job. We're going to rewrite the law. We agree with your decision, your logic, that makes sense. Thank you for that check and balance. That's what we wanted, right? Or they can say, you know what, you're wrong. And we're going to write a law completely contradicting, and that you will apply this law to those cases in the future, because we do not agree with you. There's other options, right? We talked about you can amend the Constitution. I agree with that. They can impeach judges if they're not acting in good behavior. That's constitutional language as well. But I think that last one is super, super important. They can. I don't feel like Ron Paul created that option in the Constitution. It's right there. It says, under such regulations and with such exceptions under such regulations as Congress shall make. I think that's a constitutional remedy as well. What was the other thing I was going to say? Can't think of it now.
So this is really interesting discussion, and I think the audience members are engaged in what's this dialogue that's taking place between you, because you're both making very compelling arguments. I want to explore just a little bit, the constitutionality of judicial review itself, right? You openly admitted, David, that nowhere in Article 3 is this power given to the court, and yet you seem to be pretty supportive of the idea that the court is exercising, since Marbury v. Madison, this power that basically Chief Justice John Marshall gave to the court, gave unto the court itself. How do you justify judicial review as constitutional, right? And do you think that this power that the court has given unto itself can actually be exploited or can actually be misused?
All right, we'll take that in a couple of things. Judicial review wasn't invented by the United States Supreme Court in Marbury versus Madison. It had actually existed well before then. Courts had struck down laws, most frequently state courts, and on occasion, the King's courts in England had struck down laws. And so judicial review was something that pre-existed this, and it had always been exercised by judges. And so the idea when the Founding Fathers wrote that clause that all judicial power shall be vested in the Supreme Court of the United States, what does judicial power mean? And what it means is to act judiciously, to interpret the law and to apply it to the facts. And I think that it's difficult, if not impossible, for a judge to look at a law and to not interpret it. As human beings, language is imperfect. We cannot, with precision, indicate what our meaning or our intent was in any kind of a written document. And as a result of that, somebody has to interpret that. Well, who's that going to be? Do we want the makers of the document to interpret it? I think that's wonderful, except that they don't exist anymore and they're no longer in power. Do we want the people who are currently wanting to move that one way or the other? Or do we want to try to have someone whose job is to be a judge, to judge the rightness or wrongness of something? Now, the whole thing is judges can only adjudicate cases or controversies that are actually brought in front of them. They can't create cases and controversies. Legislators can. Presidents can. But judges can't. They have to have somebody bring a case in front of them, file an action, pursue a lawsuit, and raise the questions legitimately with facts that relate. So these are not imaginary or manufactured circumstances. They are real. And every time a judge makes a decision, you have a winner and a loser. And so they are making real-world decisions that are impacting real people. You lose, you win. Or you win and you lose. And so I think that the issue is judges don't go out of their way to try to create things. Now, there have been times, to go to the second point, where the United States Supreme Court has made mistakes. And they have made some terrible mistakes over the years. The Korematsu case, where they basically said the internment of Japanese Americans during World War II was okie dokie, that was a terrible mistake. That was something that the United States Supreme Court should have stood in the way of. They didn't, and they probably didn't because of the fear, panic, all of the human frailties that we have that were occurring at the time of World War II, as well as likely racism and other issues that were standing in the way. But the court has a better opportunity to change those things than the legislature does. And they also have a better way of protecting those minority rights. And to me, that is really the key, is because I don't see Congress out there trying to protect minority rights. And we can define minority any way that anyone wants, whether it's gun owners, whether it's people of color, or any other thing. Congress is not out there protecting the minority rights. The judiciary is the only one that is really trying to do that.
So just to clarify one point, so essentially you're suggesting and taking the position that the idea of all judicial power shall be vested in a Supreme Court, you think that judicial power at that time was self-evident based upon how judges acted in the colonies and later in the states under the Articles of Confederation, so that the founders didn't necessarily think they had to clearly articulate what judicial power meant because it was self-evident at the time.
Yes, I do. And I think you see that in a number of the documents that are contemporaneous with the adoption of the Constitution.
Like Federalist 78.
Like Federalist 78. And you also see it in just the practices of judges. People bring a case. They have a dispute over a contract. They've got a written instrument. It clearly says A, according to Party 1, and clearly says B, according to Party 2. And a judge has to look at the language and decide, what does it really say? Who's going to win? This is just an inherent characteristic of judging. Is oddly enough, they have to judge. And that includes judging on the facts and the law, which is why we have appellate systems, because judges make mistakes. And so there is built into this that when you're done, you appeal to another set of judges to review the prior set of judges. There is no such system in Congress. When Congress decides, they are their self-validating group. And there is no appeal to anyone else except for the judiciary.
Jeff, how do you see judicial review, and how do your views contrast with David's?
Well, so a couple things. Right at the end there, I had a new thought, so I want to share it real quick. Is Congress does check themselves over and over and over and over, in my opinion. Like, in order for a bill to become a law, it has to go through like 9 hoops, right? It has to get introduced on the floor, get sent to committee, has to pass out of committee, has to come back to the second reading, go to the third reading, get majority votes in all those steps, then go switch to the other house and go through the committee, go through the second reading, go through the third reading. A lot of times come back into a conference where you have to kind of amend the bill to meet both sides. Then it has to go to the president's desk to get signed, right? I mean, there's a lot of self-checking that goes along there. I think
the fact that there's 2 houses that check each other,
Yeah.
right, embedded within the system itself.
Right. So when it has to cross over, it has to go through it again, right? One thing I want to concede, and I hadn't thought about this until David brought it up to you. I think you have a good point, and I'd like to think more about it. Congress isn't in the business of protecting minorities. I think that's a super important point to consider, and I can see that. That's very important, because otherwise Congress can ride roughshod over, which they've done over and over and over, and the Supreme Court's the one to say no. And if they're not very powerful, then the minority gets smoked, and it's super, super important that in America that the minority, we have to take care of the minority, otherwise it can become just a democracy, right? That's the whole point of having a republic, is a rule of law to protect minority rights while instilling the majority opinion, right? But what I think is really important is when a Supreme Court issues something, what the issue is an opinion. That's all the issue. And when David said, you get an opinion in a court and then you go to another court and you go to another judge and another judge, that's what they're doing is they're judging. They're making an opinion. It's crazy because we actually have like 3 or 4 layers there, 3 layers if you look at it just as simply as district, circuit, and Supreme Court, where people are saying, I don't trust your judgment. I don't trust your opinion. I want to take it somewhere else. I don't trust yours either. I'm going to take it somewhere else. I mean, cases that reach the Supreme Court is because people don't agree with the judge's opinion. They don't like their opinion. At some point, they have to stop. You can't just keep appealing and appealing and appealing. And we said, look, the final is the Supreme Court. And they're not saying they're infallible because they're
infallible because they're final because they're infallible. They're infallible because they're final.
Yeah, they're final, and that's why they're infallible. Not that they're actually perfectly right. It's just there's nowhere else to go. That's how it is. And that's why I think it's so dangerous to think of, to consider. This is just my overall view. If you say what the Supreme Court says is, instead of what the Supreme Court says is simply an opinion, then you get in trouble. And that's why I believe Article 3, Section 2 limits the jurisdiction to just the cases. It doesn't say whatever the Supreme Court decides, that's their check on Congress. What it is a check on the individual rights of the person in the case. And it should wave a big red flag if there's problems, and Congress should be able to address those problems. But it shouldn't be them acting on Congress. It's them, and I believe it says it clearly in the Constitution. It's supposed to be them acting on the actors in the case, on the litigants, on the circumstances of the case itself, not on Congress of that case. And it sends a great message, and Congress can say, oh, geez, every time this comes up, they're going to rule the same way because of stare decisis and because of precedent. But Congress is still the one in charge. And if we don't look at it that way, if we look at what the Supreme Court does as more than an opinion, then I think we get in a lot of trouble.
I think, Jeff, you make a compelling point here, right? And this is something that I've thought about as we've prepared for this discussion is, how powerful should these opinions be of the Supreme Court, right? And, I think David's articulated the fact that the Supreme Court having this check on the Congress is important, but at the same time, what judicial review has essentially provided is also unfettered kind of power of the court to basically say what the law is beyond the case itself, right? Mm-hmm. And so we've talked about Roe versus Wade, right? And in Roe versus Wade, essentially the precedent that the court established was that there's an implied right to privacy in the Constitution, and then that grants a woman the ability to not be banned from having an abortion by state governments. It took the issue out of the state's governments and out away from the people, and basically made that issue a federal issue, mm-hmm. right? I was also thinking about the case just recently decided where Justice Gorsuch, sided with the other justices, regarding Bostock v. Clayton County, right? Where essentially the Supreme Court interpreted the Civil Rights Act of 1964, which basically says that you can't discriminate someone based upon sex. They interpreted that to also include those that identify as transgender, right? And I think the challenge in looking at both of those cases is that in both of them, the court essentially read into the amendment or read into the statute what wasn't there when the statute was originally passed, right? When we think of the 14th Amendment, that was passed in the context of Reconstruction and post-Civil War, and really the 14th Amendment had specifically to do, the Due Process Clause and the Equal Protection Clause had to do with race, mm-hmm. right? And now the court is applying it to other issues, including abortion, which certainly the drafters of the 14th Amendment never would have envisioned that the courts would apply the 14th Amendment to a woman's reproductive rights, right? At the same time, I think even those in 1964 that passed the Civil Rights Act never could have imagined that the court would reinterpret that statute to also include transgenderism, which presumably wasn't on the minds of most of those legislators passing that law. So I guess in making those thoughts, and sorry to kind of go on, David, you seem to be supportive of judicial review, but isn't it a slippery slope? I mean, when you allow the justices to basically reinterpret statute and reinterpret the 14th Amendment much differently than the originators of those things, doesn't that really give the court too much power?
I don't think it does. And I'm just reminded of the words of James Madison where he questioned if men were angels. Men are not angels. And the Founding Fathers recognized that men were fallible, that they had flaws, that they had all kinds of problems and difficulties, and that we were going to make errors. But that's why there are so many different ways to accomplish things. And if we allow the legislature to do things, that's a real problem. And the other issue, I think, is that if we do away with stare decisis. Now, stare decisis is this idea that when the court decides something, that it binds all other lower courts, as well as the Supreme Court in similar cases, to decide in the same way. And that's how court decisions become law, is that they essentially bind other courts to do the same thing under similar circumstances. If we have a different kind of a system other than that, then it creates one of two possibilities. Possibility one is every single case has to be litigated all the way to the very end with no guarantee as to what the outcome will be, which completely undercuts the rule of law upon which our country is based upon. Jeff is going to work. He runs a light as it turns from green to yellow. Police officer stops him, gives him a ticket. He takes it to court. The judge says, no, that's not a violation of the law. The next day, Adam does the exact same thing. Police stops him, gives him a ticket, takes it to court, and a different judge says, absolutely, that's a violation of the law. You have to pay the penalty. How can a civilized society make appropriate decisions when they don't know what the decision is going to be for an outcome? So that ability to predict how the law is going to apply is a very important part for society and is essential to the rule of law. The second thing is if judges are not able to interpret the law and apply them generally, then that really means is that the legislature is the Supreme Court of the United States. And that just puts two roles, the judicial role and the legislative role, in the hands of the legislature. And again, I think that there's so much greater risk for tyranny and for difficulties from Congress than there is from the court. You look at the history of the United States Supreme Court, there are really only a handful of cases which people say are bad decisions. The vast, vast majority are good decisions. The same cannot be said of Congress.
So, go ahead, Jeff.
I just would like to flip that on its head and say when I talk to tons of people who vote for the president simply based on, I know a lot of people voted for President Trump simply because they wanted conservative justices. Like, I don't really care about Trump, but I want to make sure we get conservative justices. If Congress says whatever law I pass, it doesn't really matter because it depends what the Supreme Court says, whether they're going to agree with it or not and make it law, because they have to have their stamp of approval to say as it comes through the case system, right? Then who actually, so kind of a flip other side of the coin of what David said, who's actually the congressional, who's the legislative body? Well, it's the judicial branch. And then you have the judicial branch not only being the judges, but also the writers of the law. In the same way that David was saying earlier, well, the Congress is now the writer and the judge. Well, now you got the judicial branch who's not the writing it, but they're judging it, so therefore they're the ones creating law by basing their decisions, right? They're the ones who decide whether abortion is legal or not. I think that's the same argument just flipped on its head. And I think that's a problem.
I think the key, though, is that the judiciary is judging a law. The judiciary isn't reaching out and saying, hey, we want to create this right. They're having to wait until litigants come before them. And there has to be actually a conflict. And then the judges have to decide between that conflict as to who the winners and the losers are. And so I think that the fear of the judiciary being tyrannical is fairly small. And like I said, you look back at history, and there's actually very few circumstances where the judiciary has ended up being, I think, tyrannical, whereas Congress, much, much, much more likely to be tyrannical, much, much, much less likely to respect the rights of the minority opinion. And so if the judiciary is removed from its role, what you just get is the tyranny of the majority.
So just to clarify and question you one more time. So, in terms of the Supreme Court, a lot of Supreme Court justices tend to, and in recent years, have tended to interpret the Constitution broadly, right? So how do you answer to the critics of the Supreme Court, including Jeff and others, that essentially suggest that the Supreme Court interprets a statute or the Constitution so differently than those that drafted those documents that they essentially interpret the law or the amendment out of existence, right? That essentially, like in Roe versus Wade, the court kind of invented out of thin air the notion of substantive due process and the implicit right to privacy, and that essentially the other courts followed that precedent and invented rights that the court created in those instances. And so that seems like quite a significant power that the court has exercised in the last half century that does in fact have widespread implications on our political system.
And I would agree that the United States Supreme Court has significant power. And I think it is significant power. But their power is limited by the willingness of the people to accommodate the Supreme Court's decisions. And I don't like the term opinion. I mean, they are opinions, but at the end of every decision by the United States Supreme Court, it says, "It is so ordered." And so they really are the decisions, the orders of the court, not just opinions of the justices. But they do make mistakes. They make errors. But the ability to decide between a real case and controversy. And this is something that I think that unless you've been involved in litigation, it is difficult to understand. Unless you've been accused of breaking a law, or that someone is actually suing you, or you believe that you have been wronged in some way and you are now seeking redress, it's difficult to understand how real these cases and controversies are. They are oftentimes at the heart of who we are as people. And do we get things wrong? Absolutely, we get things wrong. And I think that there is criticism that judges have been a little too liberal in how they interpret the United States Constitution. But remember, the people have the ability to change those things at any time, which means that only a segment of the population is unhappy about that. And we do live in a republic where we get to vote on representatives, and those representatives then get to carry out the will of the people. But if the people don't have the will to change something, then it does continue going on in this particular direction. So in 1973, the court decides Roe v. Wade. We don't see an amendment being approved by Congress in 1974. Instead, we have that going forward, and it takes 50 years in order to correct what I think is a horribly decided decision. Roe v. Wade was a terrible decision. It was completely separated from constitutional reasoning. But the people of the United States didn't have the will to change it. And so it's easy to point at the Supreme Court and say, yeah, look at that, those 5 robes are deciding something. But it's really the fact that the people are unwilling to address the issue.
Jeff, any thoughts before we move to the Q&A?
No, I would actually agree with your last comment, is that's the problem, is people aren't willing. They aren't willing to stand up and understand what's actually going on and understand the power they themselves have. I think that is the challenge. And in a lot of ways, Congress is saying, well, we'll just, whatever the Supreme Court says, we'll just follow that. And they need to step up and feel pressure from informed citizens who say, no, you better step up or I'm not going to hire you next time to represent me. So I would agree with that part.
Well,
look at that. We got an agreement.
Hey. I must say that out of all the debates we've had, I never thought that this one would be the most kind of divisive, or that you'd have the most disagreement about this one. And so I think we've had a really nice show this evening. Let's go ahead and give our debaters a round of applause. Okay, we went a little bit long with our debate portion, which is great. It was very engaging, so thank you both. We do have time for a Q&A. And so we'd like to encourage and invite members of the audience that have questions to come to this microphone over here and to line up on this side of the room and ask your questions to our subject matter experts while you have the chance. So any audience members that like to ask questions, we invite them now.
While we're waiting for somebody to come down and ask Jeff about his shoes today.
This is a dare by a high school student. I have to wear my shoes, and it's a call out to Yahosh. Yahosh Bonner is my friend, and he's trying to teach me. I think it's either my drip is lit or my fit is dripping. Which one is it? Is it both? Either? Both. Nice.
You know, the irony is I got out of my car today and to come in, and Jeff was getting out of his car at the same time, and I saw him, and I go, oh, you got to be kidding me. I was planning to wear something similar, but I didn't dare because my wife wasn't home to approve it. So,
See, and my wife told me to wear these, so a little different there. Go ahead, Carter.
Okay. Would it be constitutional for a unified president and Congress to choose to increase the number of Supreme Court justices so they can select new justices with similar political views? And what prevents president and Congress from doing this to try to control the Supreme Court?
Well, I think if I heard your question right, you said, is it constitutional for the president and Congress? It's not. It's constitutional for Congress to do that, not the president and Congress. The president doesn't have a choice about that. Congress does. But there's actually no, if I understood your question right, there's no limit on what they can do. The composition, how many, whether, after the court packing scheme in FDR's time, Franklin Delano Roosevelt time, was once they hit 70 or 73 or something like that, then they have to retire, or then someone else comes on. They can come out with whatever scheme they want. And you answer, the second question you had is what prevents that? Nothing prevents that, except for good common sense and the will of the people saying, wait a second. Because what happened at FDR's time is the people said, no, you're going too far. In fact, FDR's circumstance is interesting because he was trying to implement the New Deal so much, and there were some conservative justices that were holding him back, who were creating a great check, which is more to David's point of why we need the Supreme Court. And they were creating this great check, and he wanted to just, let's just ditch him then. Let's just implement this scheme that gets a whole bunch of liberal justices in there. And even his own party was like, whoa, hold on. That's too far. You can't try to change the composition. Even though he was trying to do that as the president, it would have had to go through Congress to make that happen. He was trying to make that happen. There's nothing that would stop it except for that, in case when people look and say, wait, that doesn't make sense. This recent court packing phenomenon, or this excitement that we have, most people are saying that doesn't make any sense, because then it'll just keep growing and growing, and it'll turn into a very political position. It's not supposed to be a political position. It's supposed to be an impartial position. So I don't know if you want to add anything to that.
I would say it's absolutely constitutional. Congress and the president can do that, and I disagree with Jeff. I think the president
can do that?
I think the president has a role because he has to sign the bill.
He nominates. Yeah,
he also nominates. So, and then the Senate confirms. So I think together the president and Congress have to do this. And not only is it constitutional, but it has happened in the past. In fact, we have 9 justices instead of 10 for that very reason. Congress, actually in this case, over the objection of the president, decided that 10 was too many. They didn't want President Johnson to appoint a 10th and a Southern person to the United States Supreme Court. And so they reduced it from 10 to 9 because Roger Taney, the author of the Dred Scott decision, had died. And so from a historical perspective, absolutely, that's why we have 9 justices, is because of a political action by Congress to change the composition of the court. I agree with Jeff. It's a bad idea. When we start doing that, it just becomes a ping-pong ball as to who can raise the court higher, or who can shrink the court, or who can come up with a scheme to do things. I think that the current system we have is great, and I think that Congress should leave it alone. It's a good number.
Good question.
Thank you, Carter. Do we have any other questions from audience members? If not, I have a question for these two. Do we have one coming up? Okay. While she's coming, I just quickly, I was curious as we talked about, just the role of the Supreme Court and how it's increased in power over time. Don't both of you think that as we've watched the recent confirmation hearings of Amy Coney Barrett and Gorsuch and Justice Kavanaugh, I mean, the stakes are so high now because the Supreme Court exercises so much power, that don't you think that actually tarnishes our political system, the fact that because they're so powerful and the stakes are so high, and I guess this is kind of a question for David, that actually creates more problems than it actually solves?
I think that the Supreme Court is always been and always will be a political institution. I mean, they're created through a political process. I do think that the behavior at hearings has been deplorable, and that it has tarnished the process and the court. To me, it is distressing to watch those confirmation hearings now because of the way that they're carried out and the lack of civility and the lack of thoughtfulness on the part of the Senate, who should be really being thoughtful in the way that they are looking at this. When you read the documents of the adoption of the Constitution, they were convinced that the Senate was going to be a thoughtful body that really thought about things carefully. And it is really disappointing to me to see how little they think. And you listen to the hearings, and oftentimes people in hearings don't even have a chance to talk. It's just listening to speeches from senators, which is to me is really distressing.
Our next question.
Yes, I just, sorry. So it sounds like if the people are unhappy with members of Congress and the way that they are conducting their position, then they're fairly easy to remove, reelect, and switch out pretty easily. As far as the Supreme Court justices, it sounds like that because they're lifetime appointments, impeachment is really the only option for being able to remove them. So my question is if people are unhappy with the way that they are ruling in certain cases, can we remove them just for that? Or what, I guess, what are the reasons that you would need for impeachment? And I'm curious if that has happened before and how often that happens, because it sounds like something that is fairly difficult to make happen. And then if you were able to make that happen, to actually impeach several members of the Supreme Court justice would probably be very difficult. So in order to make a big difference, it sounds like it would be a really difficult thing to do. So I'm just curious what you think about that.
You want to take a stab at it?
I'll take a stab at one. My understanding, David might, and Adam might correct me, but one of the, I know, I guess I don't know for sure about the Supreme Court. I think it's early on there was a Supreme Court justice who was impeached for bad behavior. But I do know that there's a federal judge named Hastings in Florida. He was on the federal circuit, I think. I don't know if you know about this, but he was impeached for bad behavior. His bad behavior is he sat as a judge and he got bribed. He took like a $180,000 bribe, and he got impeached for doing that, because that's not what you should do as a judge. What's interesting, that guy served his time. Do you know where he's been the last 18 years? As a U.S. representative for Florida. He got elected as their House member, right? So they may not have solved the problem. They got him out of the judicial chair, now he's in the legislative chair. I just find that ironic. I find it telling. I find it discouraging. The guy took a bribe and he gets impeached, and then they elect him as their representative. Like,
I love it when Jeff makes my points for me. He's too corrupt to be on the bench, but he's not too corrupt to be in Congress. So
that's not what I said.
No, I think that's what I heard. I'm pretty sure that's what I heard.
He's a lawyer, guys. He's a lawyer. Twist my words.
I actually looked this up today because I was curious about it myself. I think there have been fewer than 40 impeachment trials in the history of the United States.
But not of Supreme Court justices.
A Supreme Court justice, they attempted to impeach a Supreme Court justice.
So that's federal judges all together.
Yeah, those are all impeachments for federal as well as executive officers. And approximately somewhere between a third and a half of them are judges. So yes, judges do get removed for impeachment purposes. No Supreme Court justice has ever been impeached. There were threats to impeach judges during the early parts of the New Deal legislation. And so that was a threat that was being levied. And there is a famous quote that says basically that impeachment is, and we'll put some quotation marks around this, whatever the heck Congress decides it is. And so even though the Constitution says that you can impeach for only high crimes and misdemeanors, there's no specification as to what high crimes and misdemeanors are. And so if the House of Representatives thinks that an action of either an executive officer or a judicial officer is a misdemeanor, which basically at the time meant bad action, then they can try to remove them. But it does require a 2/3 vote of the Senate. And that's the check on the abuse of power by Congress to remove people who are just deciding against what they want. And you know, the New Deal legislation is one of those great opportunities where we get to see that the judiciary does stand in the way of things. But we also see at that time the power of the people to change the Constitution, because the Supreme Court had ruled that an income tax was unconstitutional. And what did the people do? They passed an amendment. And
Implied in your question, though, I think, is basically they're untouchable, is what you're saying, right? The answer is they're untouchable. You can't touch a Supreme Court justice, which is all the more reason why I think we should limit and not to get too excited about them being the ultimate arbiters, because then it's like, well, geez, they're untouchable, and they make bad decisions, and we just have to sit there and take it. Like, I just think that's the ultimate anti-liberty statement, to exalt them instead of push them down as much as possible.
unlike congressmen.
Thank you for your
Right,
question.
thank you.
Thank you.
Next question.
There has been a lot of conversations about adding to the number of justices that are on the Supreme Court. What are your thoughts? Do you think more should be added, or should we stay with 9?
I think we should stay with 9. 9's worked for 150 years. The workload of the United States Supreme Court is actually been declining in years. So the 9 are perfectly able to handle things. It's kind of funny that approximately somewhere between 6,000 and 8,000 cases are appealed to the United States Supreme Court every year. They only accept somewhere between 70 to 150 cases. But those they dispose of, and that pretty much resolves all of the other 7,000 cases. And so I think 9 is a good number. I don't think we need to go higher. I really don't think that adding justices would make the workflow any easier. I think it would make it harder.
Harder, yeah.
Yeah, I think it would make it harder.
If you do a group project in school and you have 3, you're like, hey, let's add 7. Like, why would you do that? It's just gonna make it way more complicated, right? That's I think what you're saying.
Yeah.
9 is for sure. It's not a perfect magic number, but why change that? Let's focus on other stuff, type thing.
Thank you.
Yeah, good question.
Great question. Thank you. We'll have Sarah be our final question of the night.
She's
Go
trying
ahead.
Not to laugh.
Mr. Imus, where did you get your shoes?
I got these shoes are from my brother, and yes, I'm wearing them as a dare from a high school student. And so I was like, okay, fine, I'll make sure my drip is lit, or my fit
However it
is
is.
dripping. So I've got all the words and
You're getting old, Jeff.
I know, man. I don't even know what's cool to say anymore.
You know, the irony is he's got way more gray hair than I do, and that's the thing. Of course, I don't have all that much hair, but that's.
Well, thank you so much, audience members, for your questions this evening. It has been an incredibly engaging discussion. And so let's go ahead and give our debaters a round of applause. We're grateful to those who joined us this evening in our live audience and remotely, those that will be watching this meeting later on. Thank you for your participation and support. We also want to thank our AHS school administrators, Jay Clark and his team on the technology, and others who assisted in making tonight possible. Our next event will take place Friday, December 2nd at 7 p.m. here in the North Auditorium. We encourage you to invite your friends and neighbors so that they too can benefit from these really engaging discussions. To watch previous sessions or other resources, make sure to visit constitutionandcivility.org. We hope to see you next time. Thank you again, and good night.